That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption.
Time for Speaking the Truth was 2024. You missed the boat. Now in 2025, you're gonna get creamed because you're a liar. This is probably about to be the best part of the opening. Oh, this is so powerful. Wow. Oh my God. I have chills. I have goosebumps. I have everything.
Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. What did they possibly need to talk about at 2:22 a.m.? Both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. Shortly after this incident, Brian Albert got rid of his house. The whole thing. Just sold it. Dog rehomed, phones destroyed, house sold. Google search was discovered on Jennifer McCabe's phone. Hoslong to die in cold. But Michael Proctor himself has a long-standing and personal relationship with the Albert family.
Yep.
Yes, that same Albert family.
Yep. They thought she was just gonna take the police, serve 5 years for them, and call it a day. But no, she lawyered up with the best defense money can buy. Well, hello everybody, and welcome back to Buckle Up, It's the Law. Folks, today we're going to conclude Alan Jackson's opening statements in the Karen Read case from April 22nd, 2025. Today is Thursday, and today we have more witnesses in the Karen Read trial testifying, so please leave your comments below as to which witnesses are absolutely positively, Larry, you have to do this cross. You have to do this. I'm only focusing on the most essential. Otherwise, we're going to have content until the middle of next year, and nobody wants that. I want to do the essential witnesses, the witnesses that are going to be the most interesting, the ones that are going to be most interesting to you, and the ones that are going to be most interesting to analyze. So watch for those cross-examinations, watch for those impeachments, and let me know in the comments below which ones you want me to do. Without further ado, I bring you the finale of Alan Jackson's opening in the Karen Read trial from April 22nd, 2025. Not guilty, not guilty, not effing guilty. Let's go.
1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning?
Good question.
In the night of a blizzard. You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call.
The 22-second call.
You'll find that curious. And his explanation for that late-night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact.
Bull.
Until he woke up the next morning.
Butt dials.
So he says.
Butt dials galore.
Then you'll learn that that, too, is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late-night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it.
Yep.
Both of them.
Yep.
They said they never had a call with each other.
Yep.
But then ultimately,
they even said on cross-examination, it is not possible to have a full conversation in 22 seconds. Remember, I did that in a previous video. Let me show you, by the way, how you can have a 22-second conversation. You guys ready? Here, let me time it. Let me set the clock, timer, 22 seconds. Go. Hey, Brian, it's Albert. Listen, he's there. Everything okay? Well, I don't know. He's still moving, but we're going to see what's going to happen. I think it's going to be okay. You think it's going to be okay? Have the authorities been alerted? No, as far as we know, everything is good. All right, well, listen, man, we're going to hop off here, or we're good, yeah? Everything is good. I'm watching the news, nothing on the news. All right, buddy, I'll see you later. Thanks. Bye. 22-second conversation. That's it. That's how it's done. That's probably how it happened. Easy. You can have a full conversation in 22 seconds or even less than that. You can have a full conversation in 11 seconds, depending on the urgency and if both parties understand the subject matter at hand. And a murder that had just occurred is definitely going to be a very interesting and very important subject matter that both parties know they can't talk about, but they know what everyone is talking about. You see?
Confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation.
Butt dial.
A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call?
A lot of twos.
You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations.
Generations.
He literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn.
And the reason they did all that and they thought they were going to get away with it, because you might be thinking there, if you're new to the channel, if you're new to this case, you might be sitting there going, weren't they afraid of getting caught? No, they had zero suspicion that they will ever get caught. Why? Because they didn't think that Karen is going to hire the best litigator in the country to fight for her, who is going to team up with the best litigator in Massachusetts to fight for her, who's also going to team up with, I'm sorry, I don't know where Alessi's from, he's new, and Little, I think she's also from Boston. That's what they underestimated. That's what the McAlberts didn't account for. That was the unaccounted for element. They thought she was just going to take a plea, serve 5 years for them, and call it a day. But no, she lawyered up with the best defense money can buy. And shout out to the Glare, by the way. He did a fundraiser on Monday, I think, like a 12-hour fundraiser for Karen. So thank you for doing that for her, Will. And also thanks for showing some of my videos. I understand that you shared some of my work, so I appreciate that very much. Let's get back to the video.
And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you.
Yep.
He pre-selected Karen Reed from the start. And he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe. She was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence, from a forensic software program called Physical Analyzer made by Cellebrite. It's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone.
Yep, there it is.
A Google search that Michael Proctor and his investigators never revealed to us. But we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m.
Oh my God, huge.
5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, Hoslong to die in the cold. Hoslong to die in cold. Now she misspelled the first word. Hoss is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27.
Yeah, huge. He's going chronologically.
And then that search was also noted by the same Cellebrite program as having been deleted.
Deleted.
The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.?
Mm-hmm.
When the Commonwealth claims that she first learned of John's death,
6
and
a.m.
where his body was hours later at 6 a.m.
Uh-huh.
So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees.
Oh, is he about to basically do the third-party culprit? Karen was framed without calling it a third-party culprit. Karen was framed? This is probably about to be the best part of the opening. Don't forget to subscribe, by the way, and like this video. Let's get into this. Oh my God.
1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Haas Long to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house.
Oh,
not at 2:30 in the morning.
Oh my God.
And at 3:30 in the morning, that area was obstructed by a Ford Edge.
Yep.
A Ford Edge like the one the Albert family liked to own.
By the way, oh, this is so powerful. By the way, just the fact that his nickname is Lucky, the snowplow driver, he's lucky. He just showed up at the right place at the right time and had his eyes on the right thing. If he had actually pulled up, he would have seen them moving John's body to that location. That would have been insanity. I mean, obviously we wouldn't be having this, so I guess he's not that lucky, but he's lucky in the sense that he just happened to be by. He happened to be there. Wow. Oh my God. I have chills. I have goosebumps. I have everything.
The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m., and that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear.
Yeah.
Fear that something bad had happened. The evidence will establish by this time Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus, and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house, where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car.
She bumped her
with that right rear taillight.
Right rear taillight.
During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe.
Ludicrous.
They'll have no evidence of it, mind you.
Yep.
None. But they'll make the claim.
So ludicrous.
We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered.
And that's Barrows. That's Nicholas Barrows right there. It was cracked, but it was not shattered.
The light was not completely damaged. It was cracked, and a piece was missing, but not completely damaged.
Oh my God, that is huge. That is huge. They are preemptively striking with everything that they have. They're taking the whole kit and caboodle, and they're just like, jurors, here you go. You sift through this. This is what we know. You figure it out. Because clearly, John was not hit by a car. They're lying. We don't know who did it, but he was not hit by a car. End of story. Wow. Oh my goodness. So powerful.
And you won't have to speculate how that taillight got cracked originally.
Nope. Exactly.
You'll see it for yourself.
You'll see it.
It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panicked, panic-stricken and grief-stricken. Where was John? Why hadn't he come home? what had happened to him. Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him, and she was worried about possibly the worst. He had gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that
and I love that he's owning the, could I have hit him? Could I have hit him? Could I have hit him? He's owning it in opening. He's diffusing that statement, because then when Jennifer McCabe, she's going to get up there and say, I hit him, I hit him, I hit him. It's actually, could I have hit him? Could I have hit him? Could I have hit him? Oh, he's doing all the right things, Jackson.
Out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other.
Yep.
A woman desperately trying to piece together what could have happened on this tragic night.
Yep.
John didn't come home.
Yep.
And the evidence will show that Karen Reed never said, I hit him.
Yes!
Never.
Yes!
Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Seraph, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one.
Except for?
Not one civilian reported having heard Karen Reed say, I hit him.
Except for?
The facts will show that the first time this improved...
Oh, wait. Oh, I see what he's doing. He is, again, preemptively striking on the McCabe testimony and all of that other stuff. So they will not have a chance. When they start testifying about it, the jury just won't believe them. The jury will not believe them. And they're locked in. They can't change it now. It's too late. It's too late. The time for change, the time for speaking the truth was 2024. You missed the boat. Now in 2025, you're going to get creamed because you're a liar and you deserve everything coming your way. Don't forget to like this video. Did I already say that? Subscribe? Anyway.
Was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT.
She's besties.
The first person to have claimed to have heard this unrecorded and unreported statement is years-long close personal friends with a young woman named Caitlin Albert.
Albert!
You heard that right. It's Brian Albert's daughter.
They're all connected.
During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other
and that will mean something. He softens it up. You will figure it out. I'm not going to spoon feed you because if I say she has been framed, now I have to prove it. He doesn't need to say that anymore. That will mean something. I'll feed you, baby birds. You will see it in due course. And now the jury's excited. They're like, oh, this is going to be an interesting trial. We're going to get to be a part of history. We're going to be a part of, helping acquit an innocent woman. He is empowering the jurors with all the arsenal, all the weaponry that they need in order to get them on his side. And that's very easy. It's very easy to get honest people on the side of truth. It's a lot harder to corrupt a jury other than like paying them off, like some lawyers used to do back in the 1910s and 20s, which was rampant. There was a lot of corruption in the justice system, way more than it is now. And now it's corruption in different ways, like, buying off a judge and stuff like that. But again, I have no proof. It's just, come on, why would Bev unless she's just like basically family. That's why they call her Auntie Bev. But anyway, buying jurors is difficult because jurors will go to the media, jurors will go, and then they'll get paid more by the media. It'll be like, well, they gave me $100,000 to vote guilty. If you give me $250,000, I will talk to you and publicly, and you're going to make $5 million on the scoop. So everybody wins except for the ones who bought me. The McAlberts or whatever, or Hank Brennan and Adam Lally, the Massachusetts, Norfolk County District Attorney's Office, like all of those. Those prosecutors are dirty. Morrissey, all of them, the whole lot of them. I mean, sometimes I like to say I'm a prosecutor on our personal injury cases, but I'm a plaintiff's attorney. I just use prosecutor because it sounds more fun, but not in this case. I don't want to be a prosecutor. I don't want to be lumped in the same category as these screw-ups. I'm a criminal defense attorney turning into a plaintiff's attorney, and I'm still doing federal work as well. Don't forget to call us if you need us, 1-844-774-HURT. All right, let's get back to the video.
Major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family.
Yep.
Yes, that same Albert family.
Yep.
His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn.
Wild.
That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption.
Yep. Yes. Oh, he said it.
How far it went.
He said it. Corruption.
Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants. He transported the evidence. He secured it. He submitted it. He did it all. That's Michael Proctor. And he did it without any reasonable oversight.
Yep.
You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation.
By the way, let me know if you want me to do Hank Brennan's opening, just so we can juxtapose it with this one. I think it's trash. I think it's garbage. I think it's worthless. I think it's unnecessary. But if you really, really, really want me to do it, just his opening, not his direct examinations, unless like they become really, really good, just let me know in the comments below if you want me to do Hank Brennan's opening as well. And maybe I'll do a poll or something.
He lied in reports, warrants. He lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight.
Yep.
Before any taillight fragments were found at 34 Fairview.
Boom!
Appreciate that.
Now you have motive and opportunity.
He had access to the vehicle before a single piece of taillight material was ever found at the scene.
He's connected and he had access.
There were two searches. The first and second search found zero. Nothing. Nothing around John's body. Nothing in the street. Not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items. 46 pieces of bright red taillight laying in the snow.
Oh, oopsies.
Supposedly found in the exact same spot that was searched not once, but twice.
Twice.
By independent officers. Came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become
That's wild.
vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight. But you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart.
Yep.
And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence...
Oh, I don't remember that from the first trial. 5 unidentified males touched that? Oh my gosh.
Establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe.
Whew.
We'll
Wow.
also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case.
So wait, so who is it? So Brian Albert, Brian Higgins, Colin Albert, and then Chris Albert, and who else would it be? Chat, let me know who's the 5th one. Who's the 5th bad actor? Fill me in here. You got Colin Albert, Brian Higgins, Chris Albert. Who's the 5th one?
John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory.
Yep.
That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case,
Their own examiner,
a homicide.
Uh-huh.
She won't do it.
I remember this.
But they're nonetheless back
Trial
again
1.
trying to present the exact same theory to you in this trial.
Wild.
Again, the evidence will show that that is reasonable
The
doubt.
biggest gaslighting case in history.
Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing.
Yep.
But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof.
Yeah.
You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends.
Yes.
Not when the physical evidence contradicts their very theory.
Yes.
Not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you.
Yes.
Not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator
Yes.
with a motive to protect his friends. Not when the physical evidence contradicts their very theory.
Yep.
Not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you.
Yep.
Not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide.
Yep.
By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all three of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty.
Wow. Wow. Oh, I have chills, folks. I have chills. I can't believe I couldn't do it in 2 episodes. I had too much to say. But hey, more content for you guys, so it's a win-win-win. I was able to convert that opening into 3 separate episodes, part 1, part 2, and part 3 of Jackson. And we're going to continue, folks. We're going to continue with some witness cross-examination, which will also break down into parts, and we'll just start releasing it. And like I said, in any time there's a lull, if we ever reach a point where there's like witness after witness after witness after witness, they're just boring and not interesting, and there's nothing for me to do, no problem. I still have about 18 videos. Half of them are Brian Albert in trial number 1. I have Guarino, and I have Trooper Paul. And combined, it's about 18 videos, 2.5 weeks of content that I have in the hopper just in case. And if you guys want me to do any witness, let me know in the comments below. I'll be on the lookout for it. And if you want me to do Brennan's opening as well, I don't want to, of that snake, but I will if you really ask me. If you really, really ask me, I will. So, but there's got to be enough interest, because if 5 people are going to be interested and 5,000 people are not going to be interested, I'm not going to do it for those 5 people. Sorry. You got to have interest. If there's interest, I will do it. I don't want to bore you. I want you guys to watch. I don't want you to think like, oh, damn it, why did Larry release this episode? I was hoping that he was going to do blah, blah, blah. I want to make it interesting. I want to make you guys excited about this stuff. So until then, I hope you enjoyed this, and I will see you all tomorrow. Bye, everybody.